So you'll see this set of facts has already been released. Now on the 15th of October, there's a request for clarification. And then you'll see the rest of the dates on there. But I put this here to also get you to understand what kind of commitment you are making. As the motivation and inspiration starts to run out when the hard work really kicks in, I want you guys to realize now that you're making a commitment up and until April, potentially next year. At the very least, you're making a commitment over December, because as you can see, the deadline for registration is the 19th of November. Excuse me. And then the 12th of January, you need to submit your memorial. Excuse me. So, the 12th of January is quite early in the year, and that's obviously indicative of the fact that students who choose to participate in the JESSIP competition, choose to sacrifice December holidays and, most of your January holidays. Shortly after that, you have to come to the university to come and register for the next year and so forth. And then the national rounds will be in February or March, early next year, right? So that is going to be the oral rounds. You'll see the JESSIP is broken up into two different rounds. There's a written component, so you submit memorials, and there's also an oral advocacy component where you argue in front of 3 judges. All right, so just to give you a bit of a background, the JESSIP is the world's largest and oldest moot court competition. You can see 700 law schools from 100 countries around the world. JESSIP specifically focuses on international public law. So I just want to get an indication. Let me ask a question here from anyone. Who can define what is international public law for us? And don't be shy. I want this session to be a little bit more interactive than me just sitting here and speaking for the next 2 hours. Any hands? Does no one know what international public law is?
Can I try?
Yes, please go ahead.
I think international public law is the laws that are used to regulate how different nations interact with each other rather than a specific country's laws. So perhaps the laws that are used in, for example, an international court rather than a court within a specific nation. I don't know.
Yeah, that's 100% correct. I would give you full marks for that answer. So exactly as mentioned, international public law is just an international version of public law. So public law deals with the relationship between a state and its people, and in a hierarchy specifically, right? Whereas private law deals with parties that are on equal footing, so not the state. So that is, and exactly as the student mentioned now, the case concerns, the JESSIP set of facts always concerns 2 countries that have taken a matter to an international court, right? The International Court of Justice specifically, which is, basically the court of the United Nations. What I've done is I've provided a link to the website. Obviously, I don't expect you guys to be able to click on the link now, but I can always recommend you just go and look up the JESSIP website and go read a bit more about it. So what happens specifically in the JESSIP is that the UFS and every university sort of picks a team from 2 to 5 students. That depends on the university specifically. Each team must prepare an argument for both the applicants and the respondents, right? So you need to write an argument for both sides of the aisle, which is a great practice to pick up in court one day, because a habit you need to get it into is not, thinking that you are correct the entire time and starting to question yourself. So writing arguments for plaintiff and defendant, or an applicant and a respondent, is a really good way to do that. As I mentioned, there are going to be two portions to the GESIP. The first is a written memorandum or memoranda, and then the second one is the oral rounds. The oral rounds only have two speakers that argue for one side or the other, and usually speakers will get about 45 minutes in total, which includes time for rebuttal and sure rebuttal. You don't need to worry about all of the minutiae when it comes to the written memorials and the oral rounds at this point. As I said, we'll go through that as the training goes on, and as you guys have had an opportunity to actually sit with a set of facts and to start doing some of the research. All right, before I continue into preparing specifically for the GESIP moot, is there any question or any concerns, or would anyone like to make a contribution at this point? Is everyone okay? I see there's a question, yes? All right, so it doesn't seem like there are any questions at this point. I hope that is more out of excitement than out of trepidation, but I suppose we will see. So these are preparing for the moot. What I've tried to do here is to give you very practical guidance, exactly a sort of step-by-step guide of what you are going to do in the coming week or two, and also, what to look out for while you are doing that. So the first step is that you have to read the problem, or you have to read the set of facts. In the GESIP, we call it the compromis, which is from French, which means to compromise, which is basically an agreed upon set of facts between the parties, right? I want to say it is rather obvious that you have to do this, but I cannot explain to you how many students want to take part in a moot court and they haven't read the set of facts, even once. When you read the set of facts, you need to read it with a sort of fine-tooth comb, right? You need to remember what exactly is happening in that facts. You need to know what are all the relevant facts and irrelevant facts. I don't want to go into too much detail on how exactly you do this at this point, but sit there and read it once or twice. Read it before you go to bed, and then read it the next morning again, and then you read it before you go to bed again. And that's the way you start to build a decent understanding of what is happening in the set of facts. When you read the set of facts, you're always looking for the specific point that is in dispute, or it's. I think in your course they call it the legal issues. So there will often be, two broad categories of legal issues in a set of facts. The one will be a jurisdictional or a procedural issue, and the other one will be a substantive issue or issue on merit. So the difference is, in every legal dispute, there are two things that need to be proven. One, you need to prove that you are at the right tribunal or judicial body or organization or whatever body you've approached. You need to prove to them that you've done everything that you need to do to get there and you're procedurally in front of that tribunal. And then you need to prove that you have a good case. So you need to prove your client's case. So you'll see that in all of these moot courts, there's a sort of procedure that the parties had to follow to get to a certain point. And that procedural question there'll always be a dispute inside of the procedure or the jurisdiction. And there'll always be a dispute about the merit of the case. So whether one party is correct or incorrect. Once you've sort of read through the problem and you've identified two of those issues, then you need to make sure that you understand the court and what you're trying to persuade. or what is your point at the end of the day? So usually I would recommend to students that you write a summary of the set of facts. And then at the end of that, you write out in sort of a short 1 or 2 sentences what exactly you want from the court. So I've given you an example here of there is a defense of necessity to murder, right? So that's just the point that you're trying to get over to the judge, or that is going to be the point that you are trying to argue. So this is a good way to contextualize your arguments because you know what your outcome is. And therefore, it's a lot easier to find sources, and it's a lot easier to think logically about it if you already know what the outcome is going to be. You should also make sure exactly which tribunal you have approached. So, it's very difficult to give you a broad understanding because it really depends on the type of moot you're in. But what is important is that you are going to be before a specific body, hypothetically, right? And you need to ensure that whatever sources you use, for example, if it's going to come out of precedent, or you need to ensure, or if it's going to come out of academic sources, that it is actually binding on the court in front of you, right? So you know that JESIP is taking place in front of the International Court of Justice, which is great because then you know all of your precedents are going to come from decisions from the International Court of Justice. You can't use decisions that come from the International Court of Arbitration, for example, because those are obviously two very different bodies. And it'll also give you a good idea of exactly what kind of arguments you are going to advance. So because the JESIP moot deals with, with international public law, you know you're going to deal with human rights issues. You're going to deal with governmental obligations. Whereas if you take part in a different moot that deals in private law, you have to know that you are dealing with contracts and private individuals. And that's obviously going to change how exactly the type of arguments that you come up with and the arguments, how exactly you are going to put those arguments over to a court. Right? When you read a set of facts, you need to keep in the back of your mind. So what I'll usually do is I'll sit with a piece of paper next to me, and then you'll see at the bottom of my screen there, I have a sort of line. I'll separate the piece of paper into 2 sides. So I'll have the plaintiff or applicant on the left-hand side, and then the defendant or the respondent on the right-hand side. So what I'll do is I'll sit and read through the set of facts, and I'll start writing all of the facts that I think are extremely important to mention. And then I'll categorize those facts into what is in the plaintiff's favor or what is in the applicant's favor, and then the opposite of what is in the defendant or the respondent's favor. Again, I strongly recommend that you write a summary of the facts. Not only is this usually going to be part of your written memorials, but it can also be expected of you to present on. So this is why, we use it as a selection tool for the teams often. It's because it's a good way to test whether a student has actually read and understood and digested the facts. All right. So you need to, when you are, as I sort of mentioned a little bit prior to this now, once you have all of the set of facts, you are going to separate them into relevant and irrelevant facts. And then you are going to separate all the relevant facts into the relevant facts that are in the applicant's favor and the relevant facts that are in the respondent's favor. Right? So obviously, whoever your client is, or if you're acting on behalf of the applicant or you're acting on behalf of the respondent, you are going to try and emphasize the facts that are in your client's favor, and you are going to try and downplay the facts that are not in your client's favor. You also, during this fact-finding mission, it's important that you ensure that your facts are supported by credible evidence. And the set of facts, or the hypothetical set of facts, will usually contain the evidence that you are looking for. So it'll either be disputed or not disputed. But you cannot say that something is a relevant fact if it is not supported by any evidence, right? Because then, whether that fact is true or not is questionable, and you're going to open yourself up to getting questioned on that fact. All right, so then after you read the set of facts and you know what the relevant and irrelevant facts are, the facts for your client and the facts for your opponent, You have to identify and rank all of the issues that are in the dispute. So yeah, you ask yourself a few questions. The first one is, what is the actual dispute between the parties? So there you need to look at where do the parties differ? Remember that disputes can be factual and disputes can be legal. So factual disputes are obviously disputes of a factual nature. So, two people saw the same thing happen, but the way that they recount it is completely different. Whereas legal disputes, on the other hand, are disputes about law specifically, right? So it's disputes about the application or interpretation of law. And so this is also an important distinction because you back up your affirmance on factual disputes with evidence, and you back up your legal position with sources such as case law and so forth. Once you have your factual disputes and legal disputes, you have to rank them in an order of importance, right? So you go from your most important step or your most important issue to your least important issue. The important thing about, or the reason why we recommend doing this is you know how to spend your time when you are presenting these arguments. So the most important issue you obviously need to spend the most time on, not just in preparation, but also in your oral argument. But also, it is really impressive because often issues are interlinked with each other, right? So the example I use is from constitutional law specifically. So we know what the Section 36 limitation basically states. What are the requirements to figure out whether a limitation on a right is justified in South Africa? So if a limitation on a constitutional right is not logically or rationally connected to its intended purpose, then the test stops right there. It will automatically be considered an unconstitutional limitation. And therefore, there's no reason to make further arguments about whether a limitation like this would be justifiable in an open and democratic society using those various factors considered, right? And it's really impressive for a presiding officer or a judicial officer when a student or a mootie stands up and says, look, there are 3 issues before the court. We are going to concentrate on the first issue right now because, if we deal with the first issue, then there's no reason to deal with the other issues, right? So obviously that doesn't mean that all you do is you just concentrate on the one issue that you think you're going to win on because, the odds are that you don't win on that issue, and then you need to be prepared to go into the rest of it. But it does show that you have a good comprehension of how these things work, especially, in the JESIP competition and all the international competitions that we have. Usually, if a team wins, or if the strongest team or the team that persuades the court on the procedural points sort of negates any need to work on the merits, right? Because if a court doesn't have jurisdiction, then outright the court cannot even hear the rest of that dispute. All right. So after you've read the set of facts, you know the set of facts, you know all the dates, you know the relevant, so forth, then you need to start undertaking legal research. All right. I know that with Google and the sort of modern quick access to information, it is very easy to Google something and then the first
Tashante, you're not the only one. I also can't hear anything from my side.
Hello, sorry, I'm back. Thank you. Sorry about that. Data is expensive these days. I just ran into some network connection issues there. Let me get back. All right. So where was I? After now you've read the set of facts, you have all your facts, you have your dates, all of that, you need to start undertaking legal research. So legal research is going to be it's a very difficult thing to begin, but as you start to build up a foundation of sources, you'll see it becomes a lot easier after time. Because these moot courts are not made to have an easy answer, right? These moot courts are designed to get students to try and come up with interesting and innovative and creative legal solutions to certain things. So what you'll find is that when you start with your legal research, you are not going to find a single case that is going to support you immediately. You are not going to find commentary or anything like that is going to, completely blow you out the water and then, that's your research done. What you are going to find is many sources that support different approaches to coming to a solution, a legal solution. All right. Where I usually start is either academic textbooks or internet searches these days. Either if it's a national competition, look, it really depends on the access to the resources that you have, but it also depends on the type of competition you're taking part in. So obviously, if it was a national moot court and it was in a high court in South Africa or the Supreme Court or the Constitutional Court, you would have access. You could use anything from Safli or Juta or LexisNexis, Savinet and so forth. But with international law specifically, you are going to have to look through the databases dealing with the International Court of Justice. So there you are going to find, a lot of your kind of commentaries on the specific laws or the specific international treaties, but also all of their decisions. What I usually do is I start with the commentary. So once I've identified exactly which pieces, what sections in the legislation I'm dealing with, I'll go look at the commentaries that are on those specific sections, because commentaries and academic sources of that nature, although they're not usually completely persuasive, so there's not a hard and fast precedent there, but what they do is they reference all of the cases that they use, and that gives you more sources to go and read and start to build up your own sort of idea or your own arguments. When you are undertaking the research, you need to remember that you are arguing for both sides. So your research should look for unfavorable and favorable sources. And you should look at, whenever you start engaging with a source, you need to look at, is the source actually a binding source, or is it a persuasive source? There is a massive difference between a professor at a university who is well respected in international public law writing an opinion, and Joe Soap, who went on his personal blog and wrote his personal opinion about international public law. So you need to figure out how you are going to apply these cases. Are they favorable to you or not? And if they are favorable to you, how you are going to apply it. Why? You're going to have to start thinking about, why is this decision binding? And if it's not binding, why is it persuasive? Does it have the same underlying set of facts? Is it the same legal question? Does it deal with similar legal issues? You have to start thinking about the quality of your sources in this way as well. So this is also another skill that comes with legal research. It's figuring out what is the credibility and what weight can we attach to the sources that you want to use. And obviously, weighty sources that hold more sway in a court, are going to be a lot more persuasive than, as I said, Joe Soap writing personally on his own issues. right? When you start finding cases, you also need to ensure that you are not using cases that have been appealed and overturned on appeal or overruled in another case. So obviously there's a long history of these kind of cases. Courts do change their minds after a certain period of time. These kind of things can happen, and nothing is more embarrassing than trying to rely on a source, and that source has actually been overturned on appeal, or a court has, in the contemporary time, changed the position on that specific case. So this is where I speak about, you need to look at is your source credible? Is it the latest source that you are planning to use? As I mentioned, academic articles and textbooks, they're not really, I use the words really appreciated here, but it's because they're not persuasive to many judicial officers, but they can be really useful because they give you a lot of support for your argument. And they help you think about the legal issue in a specific way, right? Because that is an academic's job, is to sit there and hypothetically, argue these kind of things out. So it's a good source to have at the back of your arguments at every single time. Usually, with first-year moot courts, we differ a little bit from senior moot courts in one respect, and that is we expect senior moot students, so senior law students in general, not only to be able to go find the relevant law and to find the relevant legal position and persuade us that this is the legal position. We also expect them to go sort of up and above that and make some arguments out of principle or public policy. So it's one thing to say, look, the case law on this matter is settled. All of the opinions say, A, B, C, D. But we also expect you to have such a good understanding of the facts and the law that you should be able to make an argument about, should we progress the law? Should we, in South Africa, the big example is, should we include common law? Should we progress with the common law to bring it up into the constitutional era? And again, to give you a short example here, would a defense of necessity undermine the purpose of having the law on murder? Or would it be too open to abuse? All right. So we know the legal definition of necessity. We know the legal definition of murder. And if you put a set of facts in front of you with strong enough evidence, you can argue one way or the other. Does the defense constitute necessity? But up and above that, you can also make an argument out of principle to say, well, we should extend the defense of necessity, to certain kinds of situations. Again, if I use this example in front of us, we have this big question about, what do they call it? Battered wife syndrome, right? So that's an old term for it. But basically it is, if someone abuses you over a long enough period of time, one day you snap and, in a fit of rage, or not even in a fit of rage, you plan it and you calmly just execute a murder. And you know that for the rest of your life, you are not going to be tortured or abused by this person anymore. So obviously necessity needs to be urgent. The defense of necessity needs to be an urgent defense. So your life had to have been in danger at that time. And same with self-defense. But maybe there is a principle, like a constitutional consideration, or even a public policy consideration, why we should extend necessity beyond just urgent needs, but also, as a silly example, to proactive self-defense, where you get to shoot the first bullet. Because that really shows that you understand and you've engaged with the law about this matter. But on the other hand, it also, the people you are arguing to, so the judges for your written memorials and the judges in the oral rounds, are people at the end of the day who are also thinking of this set of facts through. So what they are going to try to do is have a conversation with you and, try and get your opinion and your position out so that they can properly test it in a court. Remember that you need to consider research and material and sources for your own arguments, but also your opponent's arguments, because this is what you are going to basically use to construct your arguments, right? So each of your sources are basically a mortar and brick building up this beautiful argument that you're coming up with one day. So I've said to you that you only have 45 minutes, and that's shared between two speakers with time for rebuttal and share rebuttal. So what you realize is that you have very little time to actually present your argument. Where your memorials can be 70 pages long, your arguments, your legal arguments are only going to be, 15 minutes, 15 to 20 minutes, if you're really lucky. So you don't have a lot of time to present your legal arguments. And your legal research, if you start early enough and you find the strongest sources, you are going to be able to present your strongest arguments and rely on your strongest arguments to convince someone, rather than completely, using up all of your time for issues that are not so important. How exactly you structure an argument is completely up to you. So obviously with your legal sources, you are going to separate it into jurisdictional issues, and then you're going to separate it into, jurisdictional and to substantive issues. So what will happen is that you'll have sources that are going to fall under either of those categories. And how exactly you structure that argument, is really your choice. Some people start with procedure first, and some people start with merit first, but it doesn't really matter. But importantly, if you're going to use sources like court judgments, or you're going to use sources like previous decisions, is you need to be able to engage with it. So you need to know what the set of facts is. You need to know what the issues are in front of that court, and you need to know the court's reasoning for coming to that end. Often what will happen in these kind of competitions is a judge will ask you, can you give me a short summary of what happened in that case? Or the judge will ask you something like, but isn't that case distinguishable from this case because of A, B, C, D? And so you need to know what exactly happened in that case and how you are using it. Again, I say, do not fall into the common trap of thinking that a case is decisive. There would be no moot if this were the case, right? So if you find it decisive, or you think you have found a completely decisive case, the odds are that it's not necessarily as decisive as you think it is, because the whole point of these moots is to not deal with decisive matters and to create an equal playing ground. All right, I want to quickly take a sip. All right. That's all I'm going to say about legal research at this point. In the next session, I'm going to go through a lot more specific and practical guidance on how to undertake legal research. As I said, today is just to give you an introduction of where do you go from here now that we're all part of this big group. All right. After your legal research, you should have a sort of skeleton or a structure of your legal argument. Remember that these are going to be both written arguments, and they're also going to be oral arguments. So it's basically just going to be a line saying specifically, this is my point A, this is my point A1, this is my point A2. It mustn't be your entire speech. In your summary, you also need to start listing all of the authorities, so the sources that you are going to rely on, including any textbooks or articles or any other material. I always give a piece of advice before you start writing your memorials. You can look up the previous moots, whoever won. So all of these moot courts, they will publish the winning teams' memorandums every single year. So that's a good place to start, because it shows you exactly what it should look like and what the judges really score when they look at your written memoranda. It is also important that as you start your legal research, you prepare what we call a bundle of sources. Right? So a bundle of sources is exactly what it says. It's basically a file that has printed out copies of every single source that you use. So it'll be all the cases, for example, It'll be all the academic authors. It'll often be the legislation that you have put in there, and it'll be the commentary on that legislation specifically. So this must obviously accord to the skeleton of your argument, and you need to work with this bundle, right? So this bundle is there for you specifically throughout the competition. So what happens often in these kind of competitions is during the memorial writing stages, we all find a great source and we quickly put it into our written memorial, and then we don't save the source or we lose the source. So that is it's a real big issue, because then at some point when you are frustrated and tired and you just don't want to participate anymore, now you're going to have to go and try and look up that source. So you're going to spend the next 10 to 30 minutes trying to find exactly what journal that source came out of, to find exactly what year that court case was decided. So this bundle of references is really important, or bundle of sources is really important there. But you're also going to use it if you go through to the oral round. So while you are presenting your arguments, you are going to sit there with a bundle of sources next to you. And remember, that bundle of sources is going to be organized, right? So it's going to be indexed. You are going to know, you are going to have leaflets inside there that are going to show you to the exact places, so that if the court ever asks you, let's say you're using a court case, like, any court case, you say, your worship, you rely on S versus Botha or whatever. Then the court's going to ask you, okay, but where in S versus Botha was that said? And if you have the bundle of sources with you, you can quickly go through it. You go through, you know where the issue is. So you go to your first issue, all the sources of your first issue. You go to the court cases. The court case is there, and you have a leaflet with where exactly that was said. So this will help you throughout the moot court. But it is also an important thing to do once you start practicing law one day, or anything that you really do, is keep your sources with you. You always build up and update your own compendium of legal knowledge and legal sources this way. If you get stuck during your drafting or during your preparation, and we all really do, you deal with complex legal issues and you read the same thing over and over and over and over again, and it never really truly makes sense, and suddenly it makes sense and then it doesn't make sense. It is okay to just stop and put everything down in front of you just for a moment, right? And then for 10 minutes, you just think about absolutely anything but the moot court in front of you. So you can go on Facebook, you can make yourself a cup of tea, you can go tell jokes, you can go for a sprint, anything you can do to get your mind off of the moot court in front of you. After that 10 minutes, you are going to sit down and you are going to ask yourself, 4 basic questions. What is this all about? How did we get here? What does my client want? And how do I or we get what the client wants? Right? So you are going to go through the set of facts again. If you have a summary of the set of facts, there's your answer to question number 1, and possibly question number 2. Once you have thought through these, I can promise you, you're going to start making progress again on your arguments. Remember that the whole process of this moot is the exercise of you coming up with arguments and supporting them, and then them being criticized, and you going back to the drawing board and improving them. All right, so that concludes the basic introduction to the moot court that I want to give you as part of this first session. I want to open up now for any general questions about senior moots or the specific Jessup moot, or if you have any concerns or anything that anyone would like to know. I figure we can have a discussion for the next few minutes to air out or clear out anything that is unclear at this point. It's proprietary. I'll have to charge you, but I can obviously share the slides. Yeah, I have no problem sharing the slides with you. I saw Nonkululeko unmuted a mic, but I didn't unmute the mic. I didn't hear anything. I assume there are no questions then. All right. So the last. Sorry. So I just wanted to make some concluding remarks, which is just a sort of general tip for the rest of your career, whenever you are going to use, or not use per se, but whenever you are going to start drafting legal arguments and presenting legal arguments, and just in general, every single day we try and persuade our friends, we try and persuade our parents and our family. We do engage with other people on an intellectual and emotional level. So there are general tips on how you can improve the way you do this. One of the first really important ones in my mind is you should never use a metaphor, simile, or other figure of speech that is always used. So often students will use a certain term that is so cliche at this point in time that it really doesn't have the effect that it has anymore. I also recommend to students that you should never use a long word where a short one will do. I can promise you that as you get better in your legal career, a lot of these big words that you hear on TV these days, and a lot of these big words that you read in constitutional court judgments about rescission applications and jailing and contempt of court proceedings, you will get to a point in your career where you know exactly what these words mean and you can use them. But when you start, it's always good to start to use the words that you understand and to use shorter words. They read a lot easier, but also they really, they are a lot more persuasive because you can get the information over a lot more clearer than you can if you use a big word. Whenever I finish writing, it's also you go over your writing again, and then you make sure that every single word that you put in a sentence needs to be there, right? So you make sure that you've used just as much space as you need in order to get your opinion over. You also, and really importantly, you should also, sorry, I'm not even sharing my screen yet. I meant to be sharing my screen. I thought you could see this. So I just so these are my concluding remarks. Also, never use passive tense if you can use active tense. Remember to always try write in active tense, to always try speak in active tense. That's really important for your persuading someone one day, but also it's a bad habit to get into when you start writing in passive tense, the way we read court judgments and so forth. And the last one is just never use a foreign phrase or a scientific word or jargon if there is an everyday equivalent. And this is especially true in law, where we have a lot of legal terms and legal jargon specifically, where we would like to think we understand exactly what the word means and exactly how to pronounce it. And then when we say it, it turns out it's not exactly what we thought it was, or we don't even know how to pronounce it correctly. So it's really good to start using, everyday English equivalents of these kind of words. So, all right, that is all that I have to present for today. I will hand over to Legal Behemoth now to finish off today's session.
Okay, thank you so much, Tashante. Thank you, Mr. Rawson. Okay, guys, so let me start speaking about the recruitment of the teams. So for the GSIP moot, we will need 4 students. So you guys would have seen that yesterday we have sent out an email that invites you guys who have submitted their details to summarize the set of facts. And then that email also asks you guys to please submit the summaries to our Legal Behemoth email address by, I think the due date is the 8th of October, if I'm not mistaken. And there's also a time there in that email. So yes, guys, if you are interested in forming or in being part of the UFS team for the GSIP moot, would you just please summarize the set of facts and then send your summaries to our email address? And then after you guys have sent those summaries and after the due date has passed, we will have assessors, external assessors, who are going to read through the summaries. And from those submitted summaries, the assessors are going to choose 4 students who submitted the best summaries, the 4 best summaries. And those students will form part of the UFS team for the GSIP moot. And the same recruitment process will be followed in the FIS moot, the FIS arbitration moot. But then for that moot, the facts have not been released yet. They will be released in due course. But don't worry, we will let you guys know once the facts are available. Okay, and then I see that Alfred is asking when is the next session. Okay, the next session is going to be on Friday, this coming Friday, the 24th of September. Same time, same place, and the topic for that session will be legal research. So another thing that we can do, guys, so that you are all sure of which topics are going to be dealt with in which session, we can just send you guys the schedule or the program that we are following for these training sessions, so that you know that, all right, on this Friday we are dealing with legal research, and the next Friday we're dealing with legal writing. So yes, that is it from my side. I don't know if is there any other question. Do you guys have more questions regarding the recruitment process? Do you guys understand? Okay, all right. That would be great.
Hello, I'm glad it's not just me. I'm glad you're also not getting responses. So it's not just me who's going, apparently.
At some point, I thought that no, maybe my network is acting up. Okay, so I'm gonna assume that everyone is fine. I'm gonna assume that everyone understands what is happening. But last thing, if you guys have any more questions during the week, you are more than welcome to text me and ask your questions, or you can, if you don't have my number, you can send an email to Legal Behemoth, and then Legal Behemoth will let me know about your question, and then I will respond as best as I can. Yeah, thank you so much, guys. Thank you so much for attending. We will see each other on Friday, same time, same place. Thank you.
Taelo, sorry, Tashante. I believe it is Heritage Day on Friday. So I just wanted to double check if you're planning to do the training on Heritage Day.
Oh, it's Heritage Day. Oh my word. Okay, Mr. Rosen, here's what we're gonna do. We will try and find an alternative Day, because I wasn't even aware that Heritage Day is this Friday. Oh goodness. So yes, we will try and find an alternative day and time, and then we will let you guys know about it in due course. Okay, thank you, Mr. Rosen, for bringing that up. I totally forgot about Heritage Day. Then I see Alfred has a question. Alfred says, so the 4 that will be selected, will they need to come to campus during December holidays, or they can work from home? Mr. Rosen, would you please correct me if I'm wrong? But I don't think that the 4 students are going to be required to come to campus during December, because since everything is online, so I think everyone can just work from home, because just like we are working from home right now. Yeah, but Mr. Rosen, would you please correct me if I'm wrong?
Yeah, look, it's not impossible. Let me say it like this. It is extremely difficult if you elect to work at home. The reason being that you are constantly engaging with your colleague, right? So, your colleagues, for example, will print new sources for you, or they'll draft new arguments. It obviously works a lot more efficiently if you are in the same room with each other. But that being said, we obviously can't force you to come to campus. What we are going to expect, though, is a certain level of work, including hours, and it needs to be quality work. So if you are going to stay at home and work on these things from home, you would still need to meet all of the deadlines. You would still need to actually put in the physical hours. And, at the end of the day, you would need to actually get to the point where you can submit the necessary documents, or, practice the oral round. For the oral round specifically, I think it'll probably work a little bit differently. What we try to do is to get both students at a single place, just because, then at least we have 2 laptops or 3 laptops at a certain venue, where if something happens to one, we can just go on to the next one. The issue that we encounter with students at home is that 2 people have to connect to the hearing from 2 different places. And if one of those faces a last mile connectivity issue, it's very difficult to sort it out while the student is there. But obviously, as you guys start working on this kind of stuff, you'll realize, what is required of you, and, we'll have to start putting in those contingencies in place in order to allow you to fully and effectively participate in the competition. Does that answer your question, Alfred?
Okay, I see that Alfred said yes, sir, it does. Thank you. Okay, guys, all right. So this Friday, it's a public holiday, so there will be no session. The next session, we will announce in due course when the next session will take place, but it will take place sometime next week. So let me just confirm again. This Friday, it's a public holiday, so there's no training session. Okay, if there's nothing from your side, Mr. Rosen, or from Tashante, or if there's no other questions, then I think we are done for the day. Thank you.